The other thing about training investigators that we have learned is, I mentioned a budget for expert witnesses. I can tell you that is the toughest thing for me to control at all, because expert witnesses don't owe me anything. We do business with some on a regular basis, and we build on the efficiencies of scale and what have you. But if you need an expert you pick a field, a particular ballistics type of expert or what have you, there's very difficult time negotiating a good price. Well, we're an indigent defense organization. Thank you very much. That'll be $400 an hour anyway. So what we found out is that we had a couple of areas of specifically gang experts. The gangs thing in California, and I don't think there's a bulletin to anybody here. I mean, I really don't know the demographics here, but gang members in our county and wannabe gang members, and the availability of firearms and all these sort of things. The California law provides for very distinct life enhancements for participation if the crime was committed in furtherance of the ends of a criminal street gang, Serenos, Norteños, who have you. And so it's very intense amount of investigation that goes into those cases. And then we get to the point of trial when the prosecution has built-in experts on gangs. And most of these people are just simply well-trained law enforcement officers who are prepared to talk about how gangs work, how your guy's definitely a member of the gang, what tattoo he has on his left arm, what tattoo he has right on, all the indicia of all of that. So we would then end up in the position constantly of going out and hiring independent experts on gangs to come in and take a look and assess the DA's case, assess what their expert would be having to say, and it was costing major, major dollars. So you train your own people to be experts, qualify them as experts. We spent some money, and we sent several investigators, 3 of whom were Spanish-speaking, off to, I think it was a 2 or 3 day seminar on gangs. They learned what they had to learn. Most of them had some experience already, but they could now say they had attended the same course as the district attorney's expert, and they could be qualified as experts. And the other thing that's very valuable about all of that is those folks now are trained to look for both the strengths and the weaknesses. And knowing strengths and weaknesses in cases has a great deal to do with the cost of those cases. If there are weaknesses that we are able to discover in the prosecution's case, that case may never end up in trial, and it may go away. Cases do get dismissed. If you are able to put together a package that points out the weakness to a case, the DA's office does not want to prosecute cases they can't win. I can certainly say that in our jurisdiction. I have a great deal of respect for our district attorney's office, and I've known the district attorney for 3 decades. He at one time was a private defender program lawyer before he ran for office. He does not want people who didn't commit a crime being in jail, and he does not want to lose. So cases get resolved shy of what they're charged with spending a couple of bucks to save a whole bunch of money. So spending money strategically can be a good idea. Another example, it bewilders me. I will never understand, but I know it's a trend. Young folks who commit robberies, the first thing they do after they pull their gun out is say, give me your wallet and give me your cell phone. Brilliant. You use the stolen cell phone about 5 minutes after you've done the robbery. The police can track exactly where that phone call was made with precision. So we had cell phone technology was built, and we kept popping it up in every kind of case, everything from murder to robbery. The cell phone technology kept popping up, and I kept signing checks to expert witnesses in cell phone technology. So we said, well, wait, this is getting old. Why don't we why don't we hire an expert to come in here for an 8-hour seminar, send 15 investigators to that seminar so they know what to look for the next time they get this stack of coordinates and all this stuff for cell phone technology. That's strategic spending. I don't have to call an expert right off the bat every time the DA says we're going to introduce telephone technology stuff. The investigator could take a look at that, advise the attorney what kind of shape we're in, and it makes a well-informed decision both for the lawyer and, most importantly, for the client who makes the call on whether to try a case or not, because they are doing the time, not us. So we could give them a reasoned that gives them the opportunity to make a reasoned decision about what to do with their case, because we have our own experts. We grew them, if you will. I was going to write, when I was putting this together, I was going to write, grow your own experts, but I thought, California has that pot initiative on the ballot, and I said, no, our friends in Texas are going to think I'm promoting dope, which I'm certainly not. Another thing I want to talk about is the team concept. We already mentioned team concept in private defender programs. I have learned, or believe I understand, that the vast majority of defender organizations in this country have the one case, one investigator philosophy from which they will not budge. And that is, Joanne, you're assigned to this case. Lawyer, this is your investigator. And that's it. There's one. There wouldn't be anybody else involved. That's the investigator. We found that to be wildly cost ineffective under certain circumstances. For example, if we have, as we do, an investigator who teaches at the police academy crime scene diagram, if you have an investigator in the field who comes across with a lawyer a need for a crime scene diagram, and yet they're not really excellent in that, which means they could bill me 15 hours for drawing a crime scene diagram that may be less compelling than I send out Rich, the investigator with the expertise. He spends 2 hours putting together a dynamite 2-scale, to-the-inch diagram of everything about that crime scene. It makes no sense, one case, one investigator in a lot of cases. We track, in terms of measuring, again, performance of the investigators. During the course of this last fiscal year, we had 57 cases where we call assists, and that's 57 cases where we had other investigators with particular forms of expertise go out and assist the primary investigator in the case. It's strategic spending, it saves money, it's not wasting money. The dangers of underutilization. This is something that all the lawyers in the room, I think, understand very well. But to the non-lawyers in the room, it may be hard to understand. Law enforcement agencies, at least in California, are hurting as much as anybody else. All right? And it has been very disturbing for me for the last several months to see some of the results of that. Some of the results are some factually innocent people. If they had spent a couple of more hours interviewing a couple people, they wouldn't be sitting in jail for months at a time before. Now, does that mean they're bad guys? Absolutely not. When you're cutting police agencies back, let's say you had 5 officers who usually cover a particular shift, and now there's 3, and a crime takes place that needs investigation, what are they going to do? Take 3 police off the street so the community is unprotected? Or they'll just do a minimal report, get it in, and say, well, we got the right guy, and that's it. They're getting cut back too, and it is in our county, and I put in the booklet here that Terry put together for you. There's a couple of very compelling examples of factually innocent people who were charged with offenses where we talked to witnesses. I'll give you the real thumbnail of one. A homeless woman, mental issues. John Q. Public is in a line at a Jack in the Box. That's a fast food restaurant in California. I don't know if he had that here. His wife and his kids, they're in the car. They're going to go get a burger, and they see over the side, they see a woman lying on the ground with some guy standing over her, apparently homeless guy, kicking her in the head over and over and over and over again. The guy gratefully gets out of the car, approaches the guy, said, knock it off or I'll call the cops. The guy says, go ahead, but he walks away. And the citizen called the police anyway. The police come out, like 3 or 4 police. One police officer goes up and interviews the guy, and he said, nothing happened, I didn't do anything. They interview another homeless guy who was the friend of the male involved in the scene, and he says, she was beating up on him. A third police officer interviews the citizen who had no dog in this fight, right? And he tells the police officer exactly what he saw. We get the police reports, and we assign the case to a young lawyer. The police officer wrote, arrived at scene, white male adult on the ground, female adult kick him in the head. And exactly the opposite of what was told to him by the citizen witness. We get an investigator, goes out. The citizen said, I'd be happy to talk to you. He shows him the report. And the citizen goes ballistic. He says, exactly the opposite. That's not what I told him. Now, is the police officer a bad guy? No. He was too pressed. He dictated this report, probably never proofread it. His sergeant signed off on it, the sergeant who was never at the scene. We have a woman who's threatening suicide because she's mentally ill in the jail, calling a lawyer 4 times a day. I'm going to kill myself if I spend any more time in jail. I'm going to kill myself. Case dismissed. The wrong person. That's a pretty basic example, but they're getting hurt too, and it has an effect. Everything has an effect. It's touching each other. The cost of wrongful incarceration, you know, the family devastation, and I think Jim mentioned this earlier, the bad guy's still on the street if you have the wrong guy in jail. They're still out there, okay? They're still there. It doesn't change. Who knows? It's impossible to measure that cost, but that's there. But the cost of overcharged cases, a thing, at least in California law, I mean, they think of us as the Sunshine State and everything's happy. It is one of the most punitive penal systems in the world, not just in the country. The California system, 3 strikes law and what have you, is very, very punitive, and the sanctions are stupendous. So if a case is overcharged and you don't do your job of investigating, mitigation investigation is one of the most important parts of the investigation job. Real short example, because we have a record procurement component too. We have people who are 124 cases this year went out and got records of prior convictions that were charged under the 3 strikes law, and our job is to investigate those. Case in point, a guy was looking at a long time in prison for a robbery. He was charged with a prior robbery, and the police report says, brutal carjacking, a guy pushed me and screamed at me and swore at me and pulled me out of my car and jumped in the car and drove off with. This is a prior conviction from 5 years ago or something. So we went out and found the witness, the investigator did, talked to the woman. She said, how did that get written? The poor guy, yeah, I'm mad. He carjacked me, all right? But he said, ma'am, I'm really sorry I have to do this. You know, I'm very, very sorry. I'm desperate. I have to take your car. That made a whole ton of difference when it came to sentencing this guy. Was he guilty of a robbery? Yes. But there's robberies and then there's robberies. Okay, and under, you know, and so it had a great effect on the amount of time this man was going to spend in prison. And I think above all, you got to look yourself in the mirror at the end of the day and say, what kind of job are we doing? Do we have misdemeanor justice and felony justice? Do we have adult case justice and misdemeanor justice? Or are we providing due process of law as we are obliged to do? This is not a choice, it's an obligation. Are we doing it or are we not doing it? So let me move on because I'm watching that clock up there, and I know Jim Bethy's got a quick trigger on that clock. He's got, his hand will go up, sit down. Okay, but I want to say before I go on to performance measurements, you've already heard from Jim on that, and I'm going to hold up a little bit, and I'm going to give some of it. But what I want to emphasize, I really would like at some point here, when I get through with this remark, or frankly, even before I get through with these remarks, to invite your questions, to invite your feedback. This should be interactive. You know, I'm not the oracle with all the wisdom here, and we all learn from each other, and your questions are respectfully invited. Measuring attorney performance, in our view, and the way we've set up our performance, you can talk about measuring the individual performance of the individual lawyer, and you can talk about systemic performance evaluations, but the two, there is an intersection. They are intimately related to one another. And in this booklet, so I don't repeat a lot of things you could read, we have several of the benchmarks, performance benchmarks that we have with the County of San Mateo and what we measure in terms of the performance of the organization as a whole. Let me see, make sure I'm in the right thing. You know, there is a myth that goes around managed assigned counsel programs and assigned counsel programs that because the lawyers are independent contractors, you can't demand or measure any performance for them or standards. And this, I mean, it sounds crazy on its face, but there's a whole lot of people who say, well, that lawyer's in private practice. You know, they have a license. They're going to do what they want to do. That is not the way to do business. If you're going to have your bathroom redesigned and you hire a contractor, You're going to tell that contractor, I want this kind of tile, I want those kind of faucets, I want Italian marble tile. I know, yes, I know, my wife got it done recently and I'm still paying. I'm kidding. But you do. They're an independent contractor. They're not your employee, but there are standards. This is the standard. So what we did is we decided the standards were essential, and so making standards public and publishing them is crucial in our view. This, just for an example, is what we call the Attorney Manual of Policies and Procedures for Independent Contractor Attorneys, the Private Defender Program. One of the important things about dealing with independent contractors, particularly attorneys, is that buy-in is an important thing. We had 7 of the best attorneys in the Private Defender Program spend 18 months writing the policy and procedures and the standards that lawyers for the Private Defender Program are to live up to represent Private Defender Program clients. Representing clients in the Private Defender Program is not a right. It's a privilege. They're independent contractors. After 18 months of effort, we had a seminar put on by their fellow Private Defender Program lawyers. And I mean, we're talking about the best lawyers in the business. The chair, Connie O'Brien, has tried cases in 3 different states, and she got this thing done. And when those lawyers sat up there and said, these are the standards that we are all going to live by, you get each lawyer to sign off on it. Okay, there's no question. There's a sign-up. I've read this. I understand. These are the standards. Now you have a basis for measurement. The intersection won't work in terms of measuring the performance of individual lawyers unless you have an empowered chief defender, and that includes an empowered assistant chief defender or whatever kind of staff you have. And what I mean by that is if your chief defender isn't a lawyer who can, I think I wrote it here, yeah, a walk-the-walk lawyer, okay? Not somebody who just talks the talk, but if you're going to have a chief defender who's going to evaluate the performance of individual lawyers out representing people, that lawyer shouldn't have got out of law school 2 years ago. That lawyer shouldn't have been somebody who has never tried a serious case. That lawyer shouldn't be someone who, if you're evaluating the performance of a capital trial attorney, must have tried a capital case themselves. So again, invest a couple of bucks to get somebody who knows what they're doing. That's the walk-the-walk theory. Again, when you're putting together standards, this is opinion, but I've seen some organizations that have the stepping up the ladder requirements couched in something like, well, if you've tried X cases, then you're eligible to move up to felony level whatever, felony 2. If you tried Y number of cases, you're ready to move up to felony level 3. I would urge you to be very, very cautious about that sort of a setup because it builds in the idea of entitlement. You know, Johnny may have tried 20 cases, but he may have tried 20 cases really badly. You know, it's not just a quantitative assessment. It's an assessment of quality of performance. Performance is, well, I tried 20, so now give me a robbery. Well, no thanks, Johnny. I watched some of those 20, and you're not going there. Measuring the performance of the organization, one size does not fit all. You know, the budget, let me back up. I'm shortening this up. I'm watching that clock. One of you noted here, I listed in there some of the performance benchmarks that the Private Defender Program is measured by. How did we come up with those? Are those the right ones for everybody? Absolutely not. We sat down with the county. We sat down with our own lawyers. We sat down with the county. Let's get together the things that are important. What is important? What are the things we really want to measure, much like what Jim Newhart was talking about? What things are important? We decided, for example, that first visits to clients was crucial. It is a requirement of the Private Defender Program that you must visit an incarcerated client before your first post-arraignment proceeding. We had heard some complaints, and we talked about folks in the county about, well, what's really important? Well, when we hear complaints, I never saw my lawyer till I was in a holding cell at my first court appearance. That's unacceptable. But you better measure that. You got to find a way to measure how often that lawyer may have blown that first requirement, if at all. There's different ways to do that, and I won't run through them all because it's in the annual report, which I'll refer to in a minute. It's all listed in there, all the ways we do it. One of it is we that is the assistant chief defender and I, pop in through court proceedings unannounced with the permission of the court, always. We sit in chambers. Somebody walks in and starts talking about their case, and you're sitting on the couch behind them in the judge's chambers. It doesn't take long for a trained, a walk-the-walk lawyer to figure out who's talked to their client, who's talked to the client's family, who's done his or her job. If you have a rookie sitting back there checking the boxes, they aren't going to know that this client hasn't been visited till today in a holding cell. That's unacceptable. So that's the one kind of a thing. But we did it sitting down with the county. What's important to you? Caseloads were very important to us. And I'll be short on this because our case weighting system, as you will see in the materials that were prepared for you here, and you will note that the footnotes are an integral part of that, and you'll see this gentleman's name in there a lot of times, Bob Spangenberg. The extensive studies to which, with which he was involved and published, we very much relied on those. Essentially, we tried to figure out a jurisdiction-specific number of cases that you could effectively handle in our county following the 10 principles and doing what you're supposed to be doing. And it took a lot of time, took some bucks. But it's based on empirical evidence, i.e. what a law firm does. I write down everything you do on a case and get a bunch of lawyers, and I'm shortening all this up, but it's based on Bob Spangenberg's method of figuring out how long it takes to bring a case to conclusion. So the county was certainly interested in that. They wanted to know what caseloads were. We went another step. We didn't just go with average caseloads, as you will see in those attachments. We report every year the number and types of cases by lawyer. So we don't just report an average, we report the type of cases and the number of them by lawyer. Do we use their names? Absolutely not. We use a number. If somebody in the county said, will you give us the name? Sure. But you don't publish it. You expose individual lawyers to some abuse because somebody decided they didn't like the way they were represented and say, aha, that's because you had 43 cases and it's in Johnny D's report. I know. I saw your name there. We don't do that. That's unnecessary. That you report it by attorney builds credibility. Transparent. You've heard the word transparency that Jim was talking about. I learned the hard way about transparency. And I'm not going to go on to the lengthy story about it, but transparency is absolutely crucial for the credibility of an indigent defense organization. I inherited a situation. I had a wonderful, wonderful predecessor, great man. Everybody has their things they're strong at and not strong at. And he would kind of just not talk to people in the community. He would never be caught dead at a seminar like this. Somebody from the ACLU said, we want to sit down with you and talk to you about this. He'd say, just not return the call. That was his, it was just, he'd been in it 29 years. It was just kind of very hard. It's not something he did. So by the weekend that I took the job, that I moved my office from one end of the building to the other, the weekend, I moved it down to my predecessor's office, and in the inbox, a letter from the county manager addressed to him said, please see the attached letter from the local chapter of the ACLU. Would you answer these questions? So the first Sunday on the job, I was writing a lengthy response to all of this. 2.5 years later, after the Board of Supervisors appointed committees to evaluate our performance and do all of that, I figured out what the problem was. There was no transparency, and folks assumed that we were doing things poorly. They assumed it, because they didn't know any different. They didn't know anything about us. There was no such thing prior to that time as an annual report. There was no annual report of any sort whatsoever. There were no case counting. There was no evaluation of individual lawyers. I mean, the intersection of system-wide evaluation and individual evaluation, one of the performance benchmarks for the organization is that we do yearly evaluations of individual lawyers. So evaluation of the individuals became a benchmark for the entire organization. Initial client visits, caseloads, all of these things blend together. They touch each other, and they're equally important. I've already mentioned some of these, and I'm watching that clock. I'm going to not keep you here longer than you have to be. I mentioned the mentoring program as an essential component of the way we are able to find out about performance. These aren't volunteers. These aren't people who say, well, call me on the weekend if you're having trouble with your cases. We have a very detailed, specific program for mentors to mentor lawyers as long as we feel they need to be mentored. They should run every case by that mentor. The mentors are paid. They're not volunteers. We pay them. We hand pick who the mentors are. Again, the best of the best. are going to be mentors, so the younger lawyers, hopefully in the future, will reflect the values and ethics of the lawyers who are in the mentoring program. Let's see. I'm on this one. Oh, look at that. There you are. Terry, you're amazing. Again, how to make things public, not personal. We don't use names. I already mentioned that. We send out surveys every year to the lawyers to answer. We have very specific questions. You'll see that in the materials here. I won't bore you with telling you what you can already read. But these are things that are verifiable. We are very interested in specific things. We want to know how much you used investigation. We don't have to rely on that for that. We have that internally. How many investigators each lawyer used during the course of the fiscal year, and we also, of course, measure that against what kind of cases we're giving them. If we're giving them, a bunch of driving on suspended license cases, there's not a lot of investigation involved in any of that. So if people do not use investigation, you're gone. It's that simple. It's a tool. It's an essential tool. It's crucial. You need to use investigation. That's why earlier I said you have to empower your chief defender. You can't have the chief defender say, gee, golly gosh, Mary, it'd be really great if you use an investigator. If Mary doesn't use investigators after a due process period and conversations and evaluations, then the chief defender needs to be able to say, thank you very much for your years of service, you're gone. I mean, that's my view of things. Willingness to try cases is absolutely crucial. We measure that. We ask them to report by case number, by case name, the cases they took to a trial by jury. It is our philosophy that if you don't have what I call trial credibility, I mean, I've had lawyers come in for their evaluation with me and say, well, Johnny, I get the best deals. I get all these great deals for these cases. I said, let me tell you what happens with your cases because you haven't tried any in X period of time. Friday afternoon, the young deputy district attorney's got a pile of cases she's got to take home and prepare for trial Monday morning. She's going to look through those, and she sees your name. You want to know what she's going to do with your files? She's going to dump it on her desk and not read it in the weekend. Why? Because that deputy district attorney knows you're going to sign a plea form on Monday morning. That's not trial credibility. If you don't have that, your client's not getting the best deal. Your client's not getting the best look at the case. We started tracking the number of cases dismissed on the day of trial. It is much more important to me who's on that trial calendar on Monday morning demanding a trial than lawyers who actually went out to trial, because we tracked and reported by case number. When the judges had a little conversation with me, how come you're trying a gazillion cases over here? Or the trial calendar on Monday morning is impossible. What are you guys doing? And I said, here's the list of cases that our lawyers forced to trial that they hadn't even interviewed a witness. Okay? They just read the police report and say, okay, I can prove this case. They've never interviewed a witness. We're ahead of them, Judge. We have an investigator interview the witness. So we know what the witness is going to say. And when I presented that list by case number, again, verification, be able to verify it. Lawyer says, I tried a case to jury. Electronic court record shows, yeah, the lawyer tried it, or that, so we can verify it. The judges changed their focus completely, that the DA's office needs some training and they actually need to prepare their case for the day of trial. I won't go through all of these things because I think I've kind of touched on them. Staff evaluations is important because we, it's the people component. We assess complaints. How many did this lawyer get for what reasons? We had listed by the lawyers who received the most complaints for failing to return telephone calls. The State Bar of California, that's the #1 reason for attorney discipline, is failure to maintain communication with the client, failure to return calls. And all of those people will have a chat with me during the course of the year about the importance of returning calls. And if it doesn't get fixed next year, then they'll be doing something else. And I know I've made this short, but I'm watching. I'm mindful of that clock. I won't. Great game last night, wasn't it? Sorry, I know. I would love to field any questions or ideas or anything you'd like to toss at me, except last night's game. I know.